Good morning, ladies. After we dealt with the preliminaries, 2 petitions were struck out. Petition number petition number E006 and petition number E009 were struck out, and the rulings were delivered together with the media summary showing the reasons why they were struck out. So we are left with 7 petitions, and the court has considered the 7 petitions which emanate from the same presidential election which was held on the 9th of August 2022. So upon perusing and considering the issues raised in the following petitions, E001, E002, E003, E004, E005, E007, and E008 of 2022, and the respondents thereto, we find that all those petitions raise similar issues and seek similar orders. Therefore, we order that petition 01, 2, 3, 4, 5, 7, and 8 of 2022 be and are hereby consolidated with petition number E005 of 2022, which is designated as the reigned presidential election petition for 2022. The parties will therefore be, the ending of the matter will therefore read as Raila Odinga and Martha Karua will be the first petitioners. John Njoroge Kamau will be the second petitioner. Youth Advocacy Africa and Peter Kilika will be the third petitioner. Kerif Karifa, John Josewe, Ruth Mumbi, Grace Kamau, David Kariuki will be the fourth petitioner. Okia Umtata Okoiti, Nyakina Wycliffe Gisebe, Victor Okuna, John Maina will be the sixth petitioner. Julia Nyoka Bichege, Joseph Mutua Ndonga, Simon Mwaura Njenga will be the 7th petitioner. The respondents will be William Ruto and Rigathi Gachagua, the first and second respondents. IBC will be the third respondent. Then Mr. Wafula Chebukati, fourth respondent. Juliana Cherela, fifth respondent. Irene Masiti, sixth respondent. Justice Nyangaya, seventh respondent. Francis Wanderi, eighth respondent. Professor Gurie, ninth respondent. Boya Moru, 10th respondent. And the Attorney General will be the 11th respondent. from the rulings that we delivered, we have admitted Law Society of Kenya as amicus curiae or amici curiae with ICJ, Mr. John Warubengo, Dr. Joseph Savira, and Martin Mirero. That is the order of the court for the consolidation of the matter. So the other issue that we are going to deal with this morning upon consolidation of the matter is to settle the issues for determination. The court, having considered the pleadings that were filed, the submissions, and all the documents that were filed, we have framed 9 issues that have been shared with you by now, I believe, but I'll read them out. The first issue is whether the technology deployed by IEBC for the conduct of the 2022 general elections met the standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results. Issue number 2, whether there was interference with the uploading and transmission of Forms 34A from the polling stations to the IEBC public portal. Issue number 3, whether there was a difference between Forms 34As uploaded on the IEBC public portal and Forms 34As received at the National Tallying Center, and Forms 34As issued to the agents at the polling stations. Issue number 4, whether the postponement of gubernatorial elections in Kakamega and Mombasa counties, parliamentary elections in Kitui Rural, Kacheriba, Rongai, and Pokot South constituencies, and electoral wards in Nyaki West in North Imenti constituency, and Kwanjenga in Embakasi South constituency, resulted in voter suppression to the detriment of the petitioners in petition number E005 of 2022. Number 5, whether there were unexplained discrepancies between the votes cast for presidential candidates and other elective positions. Issue number 6, whether the IEBC carried out the verification, tallying, and declaration of results in accordance with the provisions of Article 138(3)(c) and 138(10) of the Constitution. Issue number 7, whether the declared president-elect attained 50% plus 1 vote of the votes cast in accordance with Article 138(4) of the Constitution. And number 8, whether there were irregularities and illegalities of such magnitude as to affect the final result of the presidential election. And finally, what reliefs and orders can this court grant or issue? Those were the issues that the court has come up with. Then we have also made an elaborate ruling where a similar candidate, the Honorable Mwaure, was seeking to join the case as an interested party, and that application was declined because we do not allow interested parties under our rules. Therefore, the lawyer, the advocate, unfortunately, you can't make an oral application at this late stage. Printings have closed, and we have to deal with the parties that we joined this morning in the consolidated appeal.
Let me begin from the last issue, Mr. Mwangi. Indeed, it is polling stations. Following Maina Kiai, anything to be done must begin from the polling station. So where there's a reference to Belgut polling center, it refers to the polling station. So again, that should be the reference that you're talking about. So let's follow that direction. On the question of contested polling stations, I think that's resolved. You will give the list to the registrar and to the applicants and to the IEBC by close of business today. On prayer number 7, that is a typo. The reference is to forms 32As and 34As, not 34Cs. 34Cs is what, so it's 34A. And so we amend the direction to read that. On the server, Mr. Kilukumi, I think I don't have the orders here, but the last order allowed 2 agents from every interested party to appear at the centers, whether it is at Forodha House or at IBC, and that resolves Mr. Katwa Kigen's question on venue. I think from the orders, you can only have 2 venues, one at IEBC and one at Forodha House, where the Section 12 documents are at. So I think can resolve that also. Mr. Kilukumi, you can send your agents to work with the registrar and the ICT staff of the judiciary. On the question of supervised or read-only access, the ruling was specific. It is not read-only access. It is supervised access. So when you send your IT people to the servers, the IBC will understand it is supervised access, which is quite different from read-only access, which was the 2017 situation. So please allow them supervised access, which has a different meaning in IT language. What was the other issue? 34, yes, Mr. Mwangi, it is correct. Again, the error was on the book 2. Should be the book 2 of 34As, and that has a specific order as to what you do with it. Compliance is by today for the polling station that you're supposed to give. But remember also, one, the question of security, and I think that will be addressed by IBC, and that I think as Chief Justice resolves all the issues that were raised by the parties, unless I've left any. I don't think I have.
Thank you, Honorable President. Professor Wajakoyo, I think one important thing must come out is that you are a presidential candidate, and we really give you all the accolades and really respect your exercise of your democratic right, and all Kenyans many Kenyans admire you, and we believe you did a great job. However, if you, under the law, under Article 140 of the Constitution, if you are aggrieved as a candidate, you have the first opportunity, you have a right under the law to file a petition challenging the validity. You did not do that, Professor Wajakoyo. So you lost that opportunity. So with respect, you have to bear the consequences.
It is now time for the judges to ask any questions or clarifications in regard to the submissions we have had today. I will start with the Honorable Justice Tuko.
Thank you, Judge President. I have three very short clarifications that I want to seek from the team representing the first petitioner. The first one, perhaps I can direct it directly to Senior Counsel James Orengo. What is the relevance of rejected votes when computing the results or the outcome of a vote? The relevance of rejected votes. The second one, I would have addressed it to Ms. Soweto, but the team can deal with it, and you are not answering us today. The postponement of elections in certain areas, and you say this resulted in voter suppression. That people wake up one morning to go and vote for a particular category of candidates, that I go to the voting or polling station to vote for an MC A, or is it called MC? That people go to vote for senator, but not the other positions. Do we have any scientific nexus on this, or is it just an assumption that this happens? The last question for me is on the reliefs that most of the petitioners have sought. We were addressed by Senior Counsel Feroz Noroji and also Senior Counsel Professor Genda on the reliefs or the relief in Section 80, subsection 4. And I'm wondering, what are some of the elements that must be satisfied before the court can act or can grant the relief under Section 80, subsection 4? That would be all from me, my lady.
Thank you. Justice Renaud.
Thank you very much, Chief Justice. Thank you, Counsel. You've been most helpful to us, particularly to myself. I have three questions, four, I think, but very short ones. The first is to Senior Counsel Philip Murger. You addressed us on the PDF format of the forms, but in the pleadings, there is a JPEG question. Would you like to?
I would like to immediately correct that. It should be
Yes.
JPEG, not PDF.
Oh, okay. So it was JPEG. It was JPEG.
JPEG to CSV.
Okay. Would you then like to connect, because you addressed us, I think you didn't connect the JPEG to PDF and then you said CDF?
I will, but I'd just like to clarify that that was a mistake on my part.
Okay. All right. But just clarify when you answer so that we can get it right. And also in the context of the staging and tampering and so on, explain to us how that happens in real time. Give us, say, Kagera Primary School Form 34A. What exactly happened in your theory, because you say some of these things you don't have? How was Kagera Primary School interfered with the Form 34A? Number two, Mr. Arua, and this could also go to the other council appearing for the commissioners, you've raised many issues going way back before the election. The Venezuelans, mistreatment by the chairman, we're not allowed to do this and that. But we saw your clans in public reading out results. And that's what I'm calling my acquiescence question. They did all these things until the 11th hour. What evidence do we have that this is not an afterthought, that they're not doing this in good faith? What evidence do we have, apart from the question of the instructions to council, the meeting they called? Why do we have anything showing that for the last 3-4 months they documented these grievances and that there was therefore a storm brewing? My own sense of things is that when you come only at the point of final declaration, how then do we trust that in fact there were issues before? Tied to that, what role did violence play at Bomas? Because we have the evidence of the chairman that I couldn't do this because I was attacked, Gulia was attacked, we couldn't announce 27 polling station results, constituency results. What role did violence play at Bomas? I think you need to explain that as the commission, which is what you've said. For Firoz Noroji, Regulation 87.3, you've asked us to declare it unconstitutional, declare it inoperative. Please address that issue in the context of retroactivity and retrospectivity. At the time these things were happening, it was the law. You're telling us to now declare it unconstitutional. What happens to events? And you know what I'm asking about this. Mr. Ndegwa, you made a very innovative, I must say, submission regarding the diaspora vote, the number of constituencies. In answering my question, please go back to Article 89.1. 89.1 says, there shall be 290 constituencies for the purposes of the election of the members of the National Assembly. We are addressing a vote in a presidential election. Please connect 89.1 with the presidential election. Otherwise, the way you left it hanging, someone would ask the question, what has this got to do with this court and the petition before us? I thank you, CJ. I thank you, Council.
Yes, let me just take up from where Justice Lenaula has with Mr. Nduiga. Mr. Nduiga, if you look at Article 38.2, every citizen has a right to participate in elections. How then do you reconcile that with your argument on Article 89? Because constituencies don't vote, citizens do. So again, prisoners, persons in the diaspora, how are they to be provided for if we are to follow your line of argument? My next question was to Philip Murgo. I was drawing a chart when you explained to us that what you're telling us is that in the evidence that you have is that the Form 34 went into the Kim's kit at the polling station to the constituency. Then between the constituency and the public portal, the Form 38's numbers were changed. They were changed in that sequence, if I'm to understand you. Now, I don't understand much about ICT, but I presume that at the polling station, when the Kim's kit takes the image, these forms are written in handwriting. How can you explain then, so that I can understand, how a form can be changed in handwriting? This is not typing, it's in handwriting. All these forms are being uploaded and changed, different people's handwritings. How does that happen? For Ms. Soweto, she's not here, but since we'll answer later, I was curious about the issue of voter repression and her arguments on that. If we look at the Constitution, Articles 136, 177, 180, each of these elections are separately provided for. So you have the presidential election, which has its qualifications, nomination process, even the dispute resolution process of a presidential election is separate, the governor is separate, the member of parliament is separate, the MCA is separate. And what happens when a voter goes to vote, they get 6 ballots. So it's 6 ballots into 6 ballot boxes. What we have then is 6 different elections, but on the same day. So if your argument is voter repression, then is the voter repression only to the presidential election? Or is that an argument that can be used by an MCA in Kakamega County to say that because the gubernatorial elections were cancelled on that day, my MCA votes have also been affected? Or, I mean, is it just the presidential election that the voter suppression argument is standing for? Or is it all? Because they are all separate elections. So how does one election affect the other? I think those are my questions for now. Thank you.
Thank you. Thank you, Chief Justice. Just a few questions. I think this could go to, I think, Mr. Baringo. You started us off with this elephant in the room, this 50% plus 1. And I've read the submissions, I've read the affidavits. There is something still surrounding this question of voter turnout, the percentage. It's like the beginning of where the controversy is located. What is the relevance of the percentage of voter turnout to determining whether a candidate marshaled the magical number? And then back to Mr. Murgur, this staging. Again, I've been intrigued. I've been reading. If I understood you correctly, and if I understand the affidavits correctly, we are having this Form 34A. The original, which is filled, leaves the polling station to go to the National Talent Center by road, let's say, for ease of understanding. Its image leaves to go to the same destination, but this time by air. Somewhere along the line, in mid-air, the image is captured. And then all sorts of things are done before it is re-uploaded, which means, therefore, if you go to that captured image, which has been re-uploaded, you will find different content from what it had at the polling station. So to determine whether that has actually taken place, you would have to go now to the tallying center and locate that one that left by road and compare. Is it possible that that capturing in mid-air also somehow magically changes the content of the one that left by road? Okay, just because I just want to understand. Then let's get back to the 4 commissioners, because this is serious. We were informed by, I think this must have been Mr. Nyamodi, quite graphically, that the 4 commissioners were allocated roles other than those for which they were appointed as commissioners. Some were heads of protocol, I think others were media, welfare. Interesting stuff here, allocating such roles to commissioners. Why didn't they protest? Is this chairperson we are dealing with such a terror that nobody can face him and tell him you can't do this. Because now what we are hearing, these are serious disclosures. Because you can imagine I being, but because I was annoyed by, not annoyed, upset by my friend. Willis for having tried to compare
My next question was to Philip Murgo. I was drawing a chart when you explained to us that what you're telling us is that in the evidence that you have is that the Form 34 went into the Kim's kit at the polling station to the constituency. Then between the constituency and the public portal, the Form 38 numbers were changed. They were changed in that sequence, if I'm to understand you. Now, I don't understand much about ICT, but I presume that at the polling station, when the Kim's kit takes the image, these forms are written in handwriting. How can you explain then, so that I can understand, how a form can be changed in handwriting? This is not typing, it's in handwriting. All these forms are being uploaded and changed, different people's handwritings. How does that happen? For Ms. Soweto, she's not here, but since we'll answer later, I was curious about the issue of voter repression and her arguments on that. If we look at the Constitution, Articles 136, 177, 180, each of these elections are separately provided for. So you have the presidential election, which has its qualifications, nomination process, even the dispute resolution process of a presidential election is separate, the governor is separate, the member of parliament is separate, the MCA is separate. And what happens when a voter goes to vote, they get 6 ballots. So it's 6 ballots into 6 ballot boxes. What we have then is 6 different elections, but on the same day. So if your argument is voter repression, then is the voter repression only to the presidential election? Or is that an argument that can be used by an MCA in Kakamega County to say that because the gubernatorial elections were cancelled on that day, my MCA votes have also been affected? Or, I mean, is it just the presidential election that the voter suppression argument is standing for? Or is it all? Because they are all separate elections. So how does one election affect the other? I think those are my questions for now. Thank you.
Thank you. Thank you, Chief Justice. Just a few questions. I think this could go to, I think, Mr. Baringo. You started us off with this elephant in the room, this 50% plus 1. And I've read the submissions, I've read the affidavits. There is something still surrounding this question of voter turnout, the percentage. It's like the beginning of where the controversy is located. What is the relevance of the percentage of voter turnout to determining whether a candidate marshaled the magical number? And then back to Mr. Murgur, this staging. Again, I've been intrigued. I've been reading. If I understood you correctly, and if I understand the affidavits correctly, we are having this Form 34A. The original, which is filled, leaves the polling station to go to the National Talent Center by road, let's say, for ease of understanding. Its image leaves to go to the same destination, but this time by air. Somewhere along the line, in mid-air, the image is captured. And then all sorts of things are done before it is re-uploaded, which means, therefore, if you go to that captured image, which has been re-uploaded, you will find different content from what it had at the polling station. So to determine whether that has actually taken place, you would have to go now to the tallying center and locate that one that left by road and compare. Is it possible that that capturing in mid-air also somehow magically changes the content of the one that left by road? Okay, just because I just want to understand. Then let's get back to the 4 commissioners, because this is serious. We were informed by, I think this must have been Mr. Nyamodi, quite graphically, that the 4 commissioners were allocated roles other than those for which they were appointed as commissioners. Some were heads of protocol, I think others were media, welfare. Interesting stuff here, allocating such roles to commissioners. Why didn't they protest? Is this chairperson we are dealing with such a terror that nobody can face him and tell him you can't do this? Because now what we are hearing, these are serious disclosures. Because you can imagine I being, but because I was upset by my friend Willis for having tried to compare. So I'm just wondering, why is it that very serious Kenyans did not seize that chance and protest to the Kenyan people that what we are being given, the roles we are being assigned, have nothing to do with tallying and verification and carrying out our constitutional mandate. I think this is tied to my colleague here, is why to the tail end? Because I'm sure the voter out there also wants to know. So let me leave it at that.
Thank you, Honorable President. I have a few questions, and the first one would refer to the lead petitioner, or rather the main petitioner, the first petitioner, if I may say, in the lead file, which actually initially was petition number 5, E005, Raila Odinga and Martha Karua versus the respondents. And later on, after consolidation, it became the lead file and file number 1. I'm concerned with the reliefs that are sought, the alternative relief sought. The first relief relates to the issue of scrutiny, which is ongoing, and the issue of the threshold, constitutional threshold of 50 plus 1. And after the inquiry, you would like that after the scrutiny, election, and the inquiry on the election technology, all the claims which have been made, and that after there should be nullification of the results, and then an exercise of recount, and after the recount and tally, that the chair be directed to declare the petitioners as the petitioners, that's the two petitioners, Raila and Martha Karua, to be the successful, or to be the winners of the elections. That's one of the. So I was saying that we would like you to lay a basis, legal basis for this in your rejoinder. No remedy that has been pleaded is going to be taken casually. Every pleading, every relief that you have sought, we are taking it seriously as a court. Therefore, because you will not just do it cosmetically, you must be meaning it. So, is this doable? Is this feasible in law and in all other practical ways? We want justification, and from, I think even suggestions were there in 2017, but now we are here. So I would like you to firm up that and give us justify the legal basis, the constitutional basis of that, and whether lawfully, constitutionally, that is possible. Of course, we'll be coming to the issue of the capacity, after all the allegations, the capacity of that chair carrying out to be in charge of the exercise of the next process, if you are successful. But before that, okay, there's the alternative that if that's not workable, then a fresh elections take place. Now, that's the problem I'm having is that, and if an election is to be ordered to be done now, yet one of the reliefs you are seeking is that the chair and substantially the commission, but effectively the chair, you want us to hold him or to declare that he is not fit to hold public office because of his malfeasance, because of his the illegalities, irregularities, even allegations of fraud that he is perpetrated, that is not fit to carry out that exercise, to be in charge of such elections. Our constitution, I believe, has never contemplated and envisaged such a serious situation, such a lacuna. And you know, we are all peaceful, loving people. We believe in the rule of law. We believe in constitutionalism. How is that possible? What are your proposals practically on the ground? If suppose this was done, how do you want us to navigate and apply the law? Is that possible within the law? These are serious issues. These are serious remedies you're asking for. In the meantime, what is the de facto state? What is the status quo? Is that underpinned under the law? These are the questions that we would like to ask, because as you know, in Kenya we have never had a state of emergency, and we all never contemplated, and I don't wish to think about it. Finally, actually that is all, because the other questions have been asked quite exhaustively by my colleagues. Thank you.
Thank you, Judge President. The challenge one faces when they talk about the same subject at the end of a conversation by many people is that they find themselves repeating issues. But I will still ask what I had noted down during the proceedings, and you can choose the manner in which you will answer them. For Team Orengo, my concern is, and actually for everyone who has spoken about the commission, what we have heard is what, about this commission, is what some time back we had someone describing, was it an accident or something on TV, and we were told it looked like a video and drama. At least that's how I perceived the submissions on the commission. And so my concern is, when did this commission become this dysfunctional? The effect of becoming that dysfunctional? What corrective measures were attempted, if any, and with what result? My second concern is from 34A. Minor Kiai told us that this election is done not at Bomas, but at the polling station. And for the presidential election, the return of that form is first by electronic transmission. And so, the way I understand it is that a photo would be taken of the form at the polling station. A photo. I want you to tell me whether it's called a photo or what it is called. Is it called a photo? Is it called an image? Is it called what? That's the question I'm asking. And so that time when it is taken, and as it is being sent originally, is it in PDF form? So the journey, because this has to be understood, the journey from the polling station to Bomas, the things that happen in between must be described by the nature of that image at the original place, at the starting point. My other concern, language, is what is to be done as a corrective measure against the chair of this dysfunctional commission, and is it to ignore the constitutional procedures and safeguards that are already in place? My final concern is concerning the relief to declare. What I have heard since morning, because of the dysfunctionality of the commission and a few other things, is that nearly everything about Articles 81, 86, the Act, have been impugned. In fact, one of you told us that everything that would possibly go wrong went wrong. So if every process that was undertaken in this process has so far been impugned, are we nevertheless to declare? And or the petitioner in petition number 5, in fact, has more numbers. What are we to do? Are we still to declare? Irrespective of all the other processes having been impugned as you have submitted to us today. If you assist me with some direction in those issues, I shall be in a position to deal with the petitioner's case. We'll see what we will do with the respondents when their time comes. Thank you, Judge President.
Thank you. I think all the questions I had have been asked, but I'd just like to follow up on what Justice Ibrahim asked. The team on the Reid petition, they have been called Team Senior Counsel Orengo. You have asked us to find the chairman culpable of various breaches of the Constitution. And as Judge Ibrahim explained, you have even told us to find that he cannot. Should we find that there should be a repeat election, he cannot preside. My dilemma is, this is a constitutional office order. Under Article 251(2) of the Constitution, there is a detailed procedure that is provided for the removal of a constitutional office order. And what I would like you to address us is, how do we go about that? Would we be making an order that is contrary to the Constitution? Because like the judge was explaining, we are a country that believes in the rule of law, in the right of a person to have a reply, to be tried. So, you know, for the breaches that EOC has committed. Mm-hmm. And that is also related to the issues you have also cited about criminal culpability. I want you to address us on, because we have an Election Offences Act, so that if somebody has committed an election offense, they ought to have been charged and tried before the court with the jurisdiction. In this case, I know we gazetted some magistrates to deal with election offenses, And my question is whether we wouldn't be usurping the powers of the magistrates if we have to make any order regarding election offences. Then to the team led by Senior Counsel Mr. Mwite for the 4 commissioners, I still want to understand at what point the commission ceased to function as a corporate entity. Is it when the 27 constituencies were not announced? Or is it when, I am really trying to understand that, because we saw them announce regularly the results at the plenary in Bomet. We really want to understand, like the Vice President is asking, when did the commission become so dysfunctional? We really want to understand that. Is there a stage where they were working together in tallying and verifying, and then they went and announced, and then suddenly there was a stoppage because the announcements also stopped streaming live? So we really want to understand that. Then my last clarification will go to Mr. Kibe Mungai. And I want you to answer this and tell us how you know that IEBC did not make arrangements for certain categories of people to vote, especially the IEBC staff. How do you know they did not vote first before they started the exercise? Because they were in a polling station, they could have transferred their vote to the station where they were conducting the exercise and voted. Because this seems quite subjective, so you needed to explain more that 700,000 people did not vote because IEBC did not make arrangements. I think those will be my questions or clarifications that I will be seeking from Council.
Justice, I have one follow-up. May I pick right on your last question? Section 6 of the IEBC Act, 6.1, says that the chairperson of the commission shall be a person who is qualified to hold the office of judge of the Supreme Court under the Constitution. Then 7A says that the chairperson or member of the commission the office shall become vacant if the holder dies, resigns from office by notice writing to the president, or is removed from office under Chapter 6 or Article 251. In that context, if perchance we were to order removal of Chebukati as chairman, would the commission still be intact with the remaining 6 commissioners without a chairman of that qualification? I'm just wondering for my own sake. Thank you very much, Chief Justice.
I think that brings us to the end of today's proceedings. It was a long day.
On behalf of the court, may I say this? That issue was discussed by the full court this morning. We received a full report from our technical team that was leading the exercise at IEBC, and we have been informed that the process of compliance was completed last night. In fact, when we were here and Mr. Paul Mwangi was saying that the process had stalled, we received a message soon thereafter from the team to say the process is heading to completion. So that as far as our team is concerned, the process at the IBC is finished. The process at Forever House is coming to an end shortly. And so the court has then asked me to express, in anticipation of this question, that should there be any issues left unattended to or any concerns that parties have, let those issues be addressed when you receive the report later this morning. You can address the question of what you're calling non-compliance. You can address the question of what servers you think were not accessed. You can address the question of the information that you received, your agents were there, and you, IEBC, can respond to say, what are your answers to the complaints by the petitioners' advocates, and then the court will ultimately determine what is the import of all the things you are saying. That report was meant for the court to make a decision on the issues you raised. So as far as we are concerned, that matter is spent. Please address us tomorrow substantively on each of the questions once you see the report, which is actually being prepared right now. That's all I have been informed to tell you by the court. I thank you, CJ. I thank you, Counsel.
Madam Chief Justice and the Honorable...
Sorry, Senior Counsel. I think, CJ, allow me to say this. As much as possible, let us do matters within this court. I think the debate out there is convoluting matters. And when we see documents being circulated outside the court, it only just inflames the public. Let us please keep matters right here. Let's manage our issues right here until we finish. That's all I'm saying in answer to Mr. Gunbo's concerns. But as far as the court is concerned, we're on top of things. I thank you.
Can you also share with us how those stray ballots are distributed in terms of counties? Related to that, did you have, in your analysis, did you have any instances where voters walked into the polling station, voted for the president, and no other candidate or no other category of candidates? What in this court we call the Mwilu question, in reference to my lady, the vice president, I think arising from the 2017 question that I think my lady and my lord, Mr. Justice Smokin Wanjala posed. Did you have any of those where you are issued with 5, 6 ballot papers, but you don't utilize all of them? Senior Counsel Kamau Karori, the appointment of the chairperson of the IEBC was gazetted by the chairman himself. I would like to know whether he was gazetted as an agent of the commission or he was gazetted as national returning officer in his capacity as the chairman of the commission, and whether, if it was as an agent of the commission, whether there were any resolutions preceding this appointment. I'm back to Mr. Mahat with the question of voter turnout. According to your presentation on PowerPoint this afternoon, you said there were 45,994 voters were identified through Kim's kit, and this is out of 46,229. Sorry, that Kim's kit were used in 45,994 polling stations out of 46,229. That gives us 235 polling stations, which I assume I did not use Kim's kit. Therefore, assuming that the manual system was employed to identify them, are you able to say the numbers from these 235 polling stations? I saw some figures like 860 or 86,000, 114,000. So if you can just clarify that for us. And again to Mr. Mahat, because he dealt with figures. Mr. Umtata yesterday presented also a PowerPoint to demonstrate that 1.6 million votes were cast or were streaming in many hours after the closure of voting. If you can also respond to that question. Mr. Gumbo, both Mr. Issa and Mr. George Raro, Senior Counsel, in their submissions talked about how Kenyans were following the streaming of results live. And then something happened and that stopped. Can you explain to us what may have happened for this to have stopped? My lady, those are all I have. Thank you.
Thank you, President, and thank you, Council. Again, your submissions were most helpful. We thank you. Professor Muigai, you said that the whole dispute revolves around numbers. And you were before us in 2017, and the question of Section 83 of the Elections Act was prominent at the time. Morgan versus Simpson was prominent. You were Attorney General at the time. A number of things happened around Section 83 post our judgment. My question is, looking at the quantitative test, and Professor Kindiki raised the question too around Section 83. I had it before he raised it. Could you speak to it, and what is the approach you should take in this case regarding the test to apply? Number two, again to your team, and any of you could answer it. It's not a flippant question. I'm raising it deliberately because I have reason to. I know that the events of 15th August are in our minds, but remember that there was an extra day by which Mr. Chebukati could have declared the result. Why did he not wait until that day? Violence or no violence? Perhaps you have another reason. Reach out to the commissioners, the four that are now named the four. Try and reach a consensus. Address the question of the 27 constituencies so that these suspicions that have now cropped up would not have been an issue. Is there any other reason why he did not take advantage of the extra day to do what he had to do? Mr. Oraro, I understand where you're coming from. I understand where your clients are coming from. I understand where Mr. Kenyo and Mr. Kihara and the rest are coming from. We are now in a spot where public office is becoming exceedingly dangerous. Falsehoods are being peddled, not just to those on this side, but more even on this side and those outside. So I understand the need for you to say, my clients would like to clear their names because they've been mentioned in these proceedings. But let us come back to the proceedings, the pain of social media, the pain of affidavits aside. What do you want this court to do with the information you've given us? So we have had your side of the story. We've had Mr. Chebukati's side. We've had Cherera's side and our colleagues. What do you tell the court to do in the context of this judgment, in the context of the issues for determination what we do with the matters you place before us. And while you're at it, you also mentioned Section 83. Perhaps you could also say something about Regulation 87.3. Perhaps since you appear for the Attorney General, and for the first time you're not appearing as amicus but as a respondent, could you say something about Regulation 87.3 and the question I posed to Mr. Noroji? It would be helpful for us if we could hear you on that question. I believe those are my, Mr. Mahat, I may have missed this, but I still want to clear my, this is a question I posed to Mr. Murgor as well. So the format initially is JPEG. At what point exactly does it convert to PDF? Forget the CSV story. I guess Mr. Mulgo dropped that. But I just want to understand for myself. At what point you've taken the image, you've asked all the questions, very good questions you've asked, the system has asked you the question. At what point does it convert to PDF? I thank you all very much. Thank you, Judge President.
Thank you, Judge President. My questions will go to Professor Muigai, as we've been asked by a number of parties that they've asked us to settle the law around Article 138.3 and 10. In your submissions, you suggested that the term commission can be used in multiple senses. How do we know which sense will be applied when? As a former Attorney General, perhaps you can point out to us whether it is in regulations, it is in the law, but how do we know which sense is applied when? My second question goes to the history of independent commissions, and Professor Muigai, you sat on the CKRC together with my colleague, Justice Lenaula, and you do know that the drafters of the Constitution introduced independent commissions and independent offices to deal with issues of authoritarianism, accountability, transparency, and to do away with the issue of one person having power. But from the narrative that we are hearing here in the court, there appears to be an all-powerful chair who, so what is the check for this all-powerful chair if the commissioners have nothing to do with his role? What would happen if the chair was to announce the wrong results completely? Or if he was mentally incapacitated or sick, or worst case scenario, dead? Who then would announce the results? What is the role of the other commissioners? I think this is bothering me, especially because it seems to me that your client and the IEBC suggest that the chairperson works with the CEO, and I feel a bit concerned. The CEO is not vetted by Parliament. He is appointed, but he seems to wield immense powers over and above the other commissioners. I cannot imagine that that could have been the intention of the drafters of the Constitution. So what role do these commissioners actually do? Because it hasn't come clearly. Or, for example, if one commissioner says he's in charge of ICT, what does that mean? Does it mean he's in charge of ICT until the presidential election, then he's not? What does it mean? What is the role of these commissioners? And I'm asking this question more towards trying to understand the leadership and the management in the commission as opposed to the management of the presidential election. Because I think they're two separate issues, and I'm trying to figure out whether this is a Chebukati problem, is it a leadership problem, is it a commissioner's problem? What's this problem we're seeing? I'm trying to understand that, and I'd like to hear that from you. Thank you. One more question, sorry. When the results come for other elections, so you have returning officers for senator, for governor, for MCA, and they are all announced or declared locally at the polling station constituency county, how is that information transmitted to the public? And when that information is transmitted to the public through a gazette notice, are the commissioners involved? Or is it the CEO only? Or is it the chairperson only? Who is involved in the declaration or the transmission of declaration publicly of those results? Thank you.
Thank you, Chief Justice. My first question, I think, could be addressed by Mr. Karori. In the morning, you did really argue quite strongly that when it comes to verification, tallying, and declaration of the result, the presidential election result, that really, if you look at the law, in your interpretation of the Article 138 and the jurisprudence that you say emanates from this court, you seemed to be arguing that that is strictly within the purview of the chair's mandate, and that really these other commissioners, let's say the remaining, the 6 commissioners, really ought not to be around that, because that's a role preserved for the chair. But then you said, according to the statute that establishes this commission, the enabling statute, the roles and functions of the commission, commission, are stated. One of them is oversight. What is oversight? If, in fact, the commissioners, I would have thought that one of the most important oversight roles in the commissioner's life would be when they are overseeing the verification and tallying of the presidential election result at the center before the same is then declared on behalf and for, and but for the people of Kenya by the chair. So what is oversight? I ask this because we were informed yesterday, and I think you were here, that instead of perhaps playing this role, some of them were allocated welfare scenarios, protocol, and media. But what is oversight? What would they be oversighting over? That's the question. In other words, at what point in this corporate entity scenario does the chair then disengage from the other commissioners? Be they 2 or be they 5 or 6? When do you say this is chair qua chair and this is chair as part of the commission? Because we need to understand that. We've been asked to provide clarity. Then let's go to Mahat. Mahat, there is this story about this Venezuelan. And one of the issues is whether the technology system employed or deployed was penetrated. And you did tell us, again, quite robustly, that there was no such penetration or infiltration or intrusion, whichever. But you did also concede that this Venezuelan, whatever his name is, had access to the server. But your answer was that the contract between the IEBC and Smartmatic was to supply and maintenance. So if I understood you correctly, this Venezuelan was accessing the server as part of the maintenance. So what is this maintenance? What does it entail? What was he doing there? Say he was released and locked out just before the election. So what was he maintaining in that system? maybe you just want to tell us what maintenance entails as part of that contract agreement. Then back to the question of percentages again, in terms of the turnout. I think I asked this question, I asked Mr. Orengo, but now that you may not have another, you may also want to address it. In the arguments that have been presented before us, Mr. Chebukati, the chair, first mentioned a 65.4% turnout. And then he did indicate that that was bound to change as results kept streaming in, especially if you took into consideration the number of those who had voted manually and the numbers that had yet to come in from the elders. Now, it is the petitioner's argument that if there was to be any change at all, then that percentage would have to increase rather than decrease. So I don't know. And how relevant, again, is this turnout to the determination of whether a candidate gathered 50% plus one vote? And then, you see, we have been asked by Mr. Ngatia, who do you believe among these two protagonists? Who do you believe? This question has been put to us, and believe you me, we will have to deal with it. Who do we believe? Now, the question of the National Security Advisory Council. This, I think, Mr. Oraro, this could be of interest to you. On the one hand, you are telling us that these personnel visited the premises at the Bomas to express their concern, because, of course, being an advisory council, they must have arrived at a conclusion that unless the results were released, then there was bound to be chaos. But on the other hand, the chair, in his affidavit, tells the court that the only reason the AG, or I mean not the AG, but the individuals, distinguished people for whom we have a lot of respect, paid that visit, was to tell the chair to somehow re-engineer the results in favor of one of the candidates. Now, this is not a question to you, but a question to Mr. Chebukati's counsel. Professor, you may want to, or even Mr. Karori, are we to assume that by the time Mr. Kinyo placed this call, if the intention was to influence the declaration of the results, to change it, to re-engineer it, are we to assume that by the time that call was placed, and by the time these gentlemen paid this visit, they already knew the results? Because there's no way they would have been on that mission if they had not known the results. So are we to assume that if this be their mission, are we to assume that they already knew the results? Okay. Then finally, Mr. Kilokumi, you know, you cited King Solomon. And this court treats Holy Scriptures very seriously. You came up with, you say there is victory. Because in King Solomon's story, the protagonists were distinguished mothers. But here, you called them two gentlemen. But I also remember that one of the mothers who turned out, or the mother claimants, who according to Solomonic wisdom could not have been the mother, is the one who was saying, cut the baby. But the other one, I remember, said, no, let her take the baby. Because what she was interested in is to preserve the baby. Would you be willing to advise? I rest my case.
Okay. Thank you, Honorable CJ and President of the Court. I just have one inquiry, one question for the respondents, and it may go to, actually it may be answered by either the counsel, Senior Counsel Gidu Migai and his team for the first and second respondents, or it could also be taken up at the same time by counsel for the ninth respondent. That is the team of the team of Senior Counsel Fred Ngatia. It's my understanding that one of the submissions and cases in response by the first and second respondents, on the one hand, and the ninth respondent, that is the President-elect, are placing the blame on the events of the ninth at the Tallying Center, Bomas of Kenya. That the two groups of parties are placing the blame on the first and second petitioners' agents and sympathizers and supporters during the tallying and verification. Of course, we have images. Many of us were not there. At least the bench was not there. But we have images which we saw on TV. We cannot say anything about what exactly happened. But we just know there was commotion, and people are throwing chairs, and even perhaps attempts to harm each other. But we cannot say anything about it ourselves as a bench. Neither were those matters before us in these proceedings. No evidence or allegations, affidavits. We have seen the affidavits, seen the submissions, but no actually determination or delving into any evidence. So, and yet there is a request, a suggestion that we should attribute and apportion blame among we should place the blame on some parties, particularly the petitioners, because of their agents, supporters, and therefore actually you expect, particularly I can see the submissions of the ninth respondents, and even I saw the affidavit of Professor Goulier, where he actually says he expects action to be taken to investigate those criminal election offences. So I just wanted to inquire that would you expect, having had such elaborate submissions and affidavits, would you still expect us to make a determination, apportion blame, attribute blame, yet really the matter is not before us? Neither are we witnesses, neither were we at the Bomas, neither were these matters had on merit before us. That's the question I would like you to think about and reflect. And when you come back, you will tell us whether you expect any release from us on that aspect. Thank you.
Thank you, Judge President. My clarifications will be sought from the team led by Professor Gidu Muigai, Senior Counsel. The first clarification I seek is as follows. As regards the requirements of Article 140, and just remaining within Article 140, and even considering that the 4 new commissioners only arrived in, was it September last year? And whatever it is they've been doing on a day-to-day basis, please clarify in my mind, because it's a major issue here, what the constitutional role of the 6 commissioners is under Article 140. And once you tell us what it is, just position their role against that of the staff of the Secretariat and of the chair. To the same team, and that is as per Article 138, 3C. To the same team, of course, numbers are critical. They are, for me, they are. Because that is a mandate of 138 for A and B, the threshold, the 50% plus 1. And numbers are important for as long as they are not negated by any other process. And numbers would point to a good election, a good result, if they are not affected by anything else. And if Article 138 for A and B are not enough, deriving from them, this court in 2017 told us that although numbers were very, very important, other things could affect the numbers. Now, here is my concern. With the fact of the numbers being undisputed, they are important, kindly comment on whether or not, this question flows from the first one, the walking away of the 4 commissioners to go and hold, was it an IBC meeting at Serena? Or was the IBC meeting at Bomas? But please comment on the walking away of the 4 commissioners almost at the same time as the chair was about to declare the results. And in fact, I recall, because I was glued on TV myself, among their first words were that we have done an excellent job as concerns this election. But the results that the chairman is about to release are his results. So please comment for my benefit that working out and how was it timed? You've got to know, because these are your clients, that they would be walking out of Bomas to Serena to allow all media houses, in fact, except for the violence that occurred at Bomas, the split screens of media houses would have been showing each one of them addressing us, the Kenyan voter, at the same time. In fact, at one moment there, I thought the team at Serena would give us their numbers, and the team at Bomas was going to give us their own numbers. So my concern is, does their walking out mean anything under Article 140? If it does, what is it? If it doesn't, why not? Still on numbers, and answering all of us, yours and our issue number 4 and 5, we were told, and I need clarity on this one because it cuts across 2 main issues, that the turnout, the voter turnout, was affected by the postponed election. Now, this is my concern. On the 9th, we were voting for 6 people, 6 officers. And we actually voted for 6 officers, including in the places where elections were postponed. And we were told that turnout was affected by the postponement. And since you are the central player in this thing, you could pass this to Mahat or anybody else in your team. Did the postponement affect only the vote of the president? And since we are in the habit of taking judicial notice, and since I am in a position to take judicial notice of the fact that elections have since happened in the postponed areas, have the subsequent elections returned a different result as to turnout? Because that happened, was it Monday? And we have yet to write a judgment. If they are affected, in what respect? Mr. Mahat, you told us that there is a holy place. You called it a sanctified place for the agent. And that it is the responsibility of parties to have agents. Your sister, while submitting, Ngania, told us that in 2017, we also emphasized the position of the agent. This is my question flowing from that, and it goes to the process of the election. What if there were no agents? The Article 81, I think 81E, places the burden of ensuring that we have a fair, free, transparent, accountable, and all those things, election, where, for whatever reason, agents are not present at an election. Is it not the role of the IEBC to ensure that Article 81E is upheld? And in the event, I know you said in Tiati some constituency there, in fact, there were no agents from anyone. The process, and where there are no agents, the process. Finally, we have seen somebody named the 4 commissioners as respondents. One of these petitions, or some of them, named them as respondents. I think someone had even named them as interested parties or something like that during interlocutories. But by whatever name code, they remain commissioners. I have also seen, we have seen affidavits that they have sworn, which tend to show that they take certain positions. Now, what is the position to be taken by a commissioner? Is it a position of the party, any party, or is it the neutral position of the IEBC? And when they take, as I think they have done in this case, the position of any side, what is the court to do? Did I say finally? Then I'll say the second finally. That Kenywa's call, Mr. Joseph Kenywa's call, and whatever else that happened, the night meetings, the security issues, and so on and so forth. The name of this commission starts with the letter I, which says, I stands for the Independent Electoral and Boundaries Commission. And in the body of 88 going down is that, and even in their act, they shall not be directed in the manner in which they do their work. But I want you to clarify in my mind, because it's now an issue here, when it comes to writing the judgment, what do you want me to write? There are commissioners, and we talked about the dysfunctionality. It came from you, it didn't come from this side of the bench. Of the commission, I'm glad today I have had an attempt at answering my question yesterday as to when it became dysfunctional, but I'm still waiting for answers from the person to whom the question was directed, which is the petitioners. But tell me what the IEBC was supposed to do. On the one hand, they are being told, hurry up and announce. On the other hand, the court, as represented by the Honorable Mr. Justice Isaac Lenaola, is saying, but there is still time. There is yet another day before you can announce. What is the IEBC to do? Thank you. Thank you very much. Thank you, President.
Thank you, colleagues, for those questions. I think they were quite comprehensive. The team led by Professor Geth Muigai, you can see what we want to understand is this disconnect arising from IEBC. Because when we look at Article 88, the role of IEBC is to supervise and conduct elections. I do not want to repeat this question. Why the chairman deemed it fit to allocate commissioners, I think what has been described as domestic chores, leaving the core business of IEBC to the CEO to supervise. We've been told that they did a good job in the polling stations. Polling went on well, counting, tallying, and transmission until the National Tallying Center, where they are all there, but they are not doing the core business of, according to the Constitution, they have been given other duties. This is bringing a lot of questions in our minds. Then when we look at Article 138, 3C, we see they have a law, at least to look at the current results and ask questions whether the president-elect met the constitutional threshold. Before the chairman can go and announce the results, because we all understand nobody can tinker with the forms 34 A's and B the way they have come. And you have had IMBC being likened to the Supreme Court, much to the chagrin of the judges here, because the question which was being asked, I think, by Mr. Otieno is that if 7 people are sitting on a judgment or a decision and there is a dissenting voice, why didn't the chairman tell Kenyans exactly what happened? That we conducted this election, we came to the National Tallying Center, we have these results, but some of the colleagues have a dissenting voice. They will tell Kenyans why they are dissenting. Another thing that worries us, and I think your team should answer, is why the live streaming of the results stopped. Because if Kenyans were able to follow the streaming from the beginning to the end, which was being done in the spirit of accountability and stability and transparency, then the rhyme which we were being told of the pige pige ponki would not arise, because there would have been no confusion. We know this is how things are happening, and therefore maybe the losing candidate who is being called to go to the National Tallying Center can decide not to go, because they know already the results they are on the screen. So I would also like a clarification. The question has been asked, and it was demonstrated very ably by Mr. Mahat. I would really like to follow his presentation because he did it with passion. Mr. Kirago Kemani also did it, but I think I want you, Mr. Mahat, to, just demonstrate how the forms 34A that were attached to the affidavits of the respondents were photoshopped. I think I liked your language of photoshopping, and I could follow it, but I want to understand exactly how they were photoshopped. I think that is what I would like to ask. Thank you. Oh, one more.
Thank you, CJ. Sorry, I don't know whether it has been up, but time without number, the issue of the 27 constituencies whose results, it is said, had not been included in the final tally before the announcement was made, keeps coming up. We have been told that, in fact, these 27 constituency results had been verified and tallied. But because of the commotion, somehow they would not be part of the announcement. But why did the chair, just before, when calm was restored, why would he not have included them? Because they had already been verified and tallied. Or did not include in the final so that they shouldn't be here bothering us? Why was it, where was the hurry this time? And already the results had been tallied and verified. Thank you, CJ.
Sorry, I just forgot a quick question, Professor Muigai, regarding my questions on Article 138. What is the implication of what you are suggesting on the chairpersons of other commissions? And I say chairperson, I noticed today everyone's talking about chairman. The correct term is chairperson.
Senior Counsel, I think myself that, and if I'm wrong, please correct me, that the most important day for a commissioner of the IEBC has got to be that time that they are doing the presidential election, and I think there is a reason why their term is 6 years, because our elections are every 5 years. So that, I think it's likely that in the 6 years, or whatever time one gets in, a commissioner would have to conduct an election, a general election. Let's not just say presidential, but a general election. Therefore, what is the role of the commissioner, the 7 commissioners? Back to my question number 1, and strictly under Article 140 for me, and 138, 3C. Thank you.
We have agreed to allow you to respond in the morning, considering that if you put your minds together, you'll be faster in the response than if we do it now. So we will give you 15 minutes tomorrow morning to respond, fasting tomorrow morning, to respond to those questions. Have a very nice evening. Very good morning to the court. I think yesterday we agreed on the order of business this morning. The team led by Senior Counsel Professor Githu Muigai will have 15 minutes to respond to the questions that were 30 minutes to respond to the questions that were raised yesterday.
Good morning, Madam Chief.
On the question of voter turnout, and as you respond, please bear in mind the following so that we know that you are answering our concern. In Forms 34A, some of them have the rejected ballot. That's what Mahat taught us yesterday, added to the votes cast. So that the figures on 34A are not necessarily the figures in 34B and not in 34C. So tell us, as you answer the question in your own manner and style, on voter turnout, was it calculated on the numbers in 34A, B, or C? Senior Counsel, you understand our concern? Thank you very much.
Yes, that brings us to the end of rejoinders. We are looking at Senior Counsel, Mr. Mwite, but we know very well your clients were respondents. It was only for the under-representation that we allowed them to come just after the petitioners. They do not have a right of rejoinder.
Thank you, Senior Counsel Professor Gishu Muigai, Attorney General Emeritus. From this end, and before our team leader speaks, we want to thank you for your assistance to us in the last 3 days. We want to say that if there was bad manners, we didn't see it. These things happen, and there really wasn't bad manners. We thank you for working within the very strict timelines that we gave you. Now, if you felt pressed for time, blame yourselves, because you gave us 14 days to do what ought to be done in a year, if you ask us. And while you take a break today, we continue working. We thank you, truly thank you on behalf of the team and before the team leader speaks. What you didn't know, but you may have realized, is that every day there was a marshal or a prefect from this end to ensure that you kept to your lanes. If you didn't notice, today I was the marshal. The day you laughed most, Dr. Wanjala was the marshal. That's how we work here. We work as a team. We divide roles here so that we don't all speak at the same time. And here, like things we have heard you say today, we consider ourselves equal. None of us has a veto power, but of course we have a team leader. We thank you very much. Pray for us as we undertake the next phase. It's actually not the more difficult one. You have helped us with the more difficult part, but it is intense, for which reason, therefore, we ask you that you pray to whatever God you pray to, that God will assist us to continue in the spirit we've been in for the last 1 year, and that we shall have a very high sense of discernment, and that we shall return to Kenya a judgment not less than what Kenya expects. Thank you very much, and now I ask that the team leader speaks to us.
Thank you very much, the Honorable Vice President of the Court, and for being a very, very effective marshal for today. Allow me to thank my brother and sister judges. We actually call it shared leadership in the judiciary. We take up all this responsibility together, and I'm most grateful for that. Thank you, Senior Counsel Professor Gishu Muigai, for those very kind words. All we saw, like the DCJ is saying, is very, very robust arguments and participation. We did not reckon any bad behavior. Like you see, we did not cite anybody for contempt. So we are very, very most grateful for your cooperation. Allow me also to thank the other people who worked with us round the clock. A team led by the Registrar of the Court, Honorable Letitia Washira, and the Deputy Registrars, our law clerks who have been supporting us, all the registry staff, the executive officers, and the court assistants. We also want to recognize the role played by our security, our police unit and all the police officers and security people who have provided us with security round the clock to make sure that these proceedings move on smoothly. I may not be able to mention everybody, but also to say that anybody who did something to make these proceedings move smoothly, we are grateful to them. We also want to thank the international and local observers who came to observe these proceedings. We are grateful for your encouragement, and we continue to ask, like the Vice President has said, that you continue to pray for us so that we can render judgment that promotes our constitution, that is anchored in the law, that nurtures our democracy, that brings harmony to our country, and everything good that is stated in our constitution. So with those remarks, I will wish you a very nice evening, and as we retire ourselves to continue working. Thank you very much. I'm told that we will deliver our judgment on Monday the 5th. We shall give you notice closer to that day. I don't know, we have only tomorrow and Sunday. But we'll give you notice indicating the exact time when that will be done. It will definitely be on Monday. But I'm reminded that Monday lands up to midnight. So you'll be given the time indication in the notice. Thank you very much. Have a very nice weekend and a nice evening.
But we are about to